A common frustration among veterans that we hear in the office is, the VA lowballed my rating. If you believe the VA has inaccurately assessed the rating of your service-connected impairment, you can take action to reverse that assessment. The VA disability benefits process is often hard to understand. The VA has complicated rules and procedures for assigning disability ratings. It can be confusing. That's where we can help. We regularly produce fresh video content to help you untangle the ever-changing VA process. To stay in the know, hit the subscribe button. If the VA has lowballed your disability, know that you have the right to appeal the rating and also that you're not alone. Don't be discouraged, and if you believe you have a legitimate claim for a higher rating, our VA disability lawyers can fight to get you the VA re-examination for your rating. The first step is to file an appeal. You must act within 1 year of the initial rating decision to preserve your effective date for retroactive benefits. You have 3 appeal options to dispute a VA decision. You must choose one of the 3 processing lanes: the higher level review lane, the supplemental claim lane, or an appeal to the board lane. If you have no additional evidence to submit in support of your claim, but you believe there was an error in the initial decision, the higher level review lane is the option you should go with. The higher level review officer will only consider evidence that was in the VA's possession at the time of the prior decision. You or your attorney will not be able to add new evidence if you're in this lane. However, you can provide a new argument based on the evidence in the file. If you have additional evidence that is new and relevant to support your ratings claim, then you may want to select the supplemental claim lane. The VA says the new evidence is evidence submitted to the VA for the first time. It cannot be information that is already in the VA records. It cannot be evidence a veteran has previously provided to the VA, or evidence the VA has legally acquired on your behalf. To be relevant, evidence must have a legitimate influence or impact on the VA's decision about your claim. Evidence previously reviewed in the decision that denied your claim can be found in your notification letter or rating decision. This may help you determine if the appeal evidence you're submitting is new and relevant. If you prefer, you can appeal your case directly to the Board of Veterans' Appeals. You have 3 options for board appeals. The first is direct review if you do not want to submit additional evidence or have a hearing. You can provide a written argument with your direct review appeal. Your next option is evidence submission, where you or your attorney submits additional evidence without a hearing. And a final option is to request a hearing in front of a veterans law judge where you submit additional evidence. If your claim is denied in any of the 3 processing lanes, you do have the right to resubmit your claim or appeal to the Court of Appeals for Veterans Claims. Because each appeals case has its own unique set of facts and conditions, there is no one-size-fits-all to stake a claim for an increased rating. Choosing the best lane is best decided on a case-by-case analysis. Therefore, it is best to consult with a VA-accredited attorney to talk about your options and get guidance in deciding what makes the most sense for your individual case. You can contact Cuddigan Law to get a free evaluation of your case and advice for your specific situation. We are accredited VA disability attorneys who have been supporting veterans for years. If you hire us to fight for your rights, we only get paid when you win your case.